are when separate companies join and become one entity.
When two become one.
Mergers occur when two companies combine and become one new company.
Acquisitions happen when one company purchases the assets of another company.
There are obvious potential commercial ramifications of a company gaining market dominance through mergers. One such example includes the control of market prices, or price wars. It is in these circumstances that the law in Australia steps in to mitigate and prevent damage to the market, and to protect the consumer from being taken advantage of by monopolies.
Before 1992, the legal test applied in determining whether a merger was anti-competitive was whether or not, as a result, a corporation would dominate a market. The threshold now is whether or not competition in a market would be substantially lessened.
Let's look at some merger cases. QIW and Davids. QIW and Davids were both large holding companies who both distributed wholesale grocery products to independent retailers. They also had some small retail outlets. They're distributed throughout Queensland and northern New South Wales. Davids owned just under a quarter of QIW's shares. They lodged a proposal with the Australian Securities Commission to acquire more than half of QIW's shares and consequently merge the companies. QIW challenged this proposal on the basis that it breached Section 50 of the Trade Practices Act. Section 50, subsection 1 restricted a corporation from acquiring shares in a company and merging if it meant they would be in a position of market dominance. Here the court had to decide what the relevant market was and if a merged entity would be likely to dominate. QIW argued that the market here was restricted to the wholesale distribution level and therefore a merger would create one dominant entity by removing the largest competitors. Davids argued that the market included wholesale and retail levels and therefore a merged entity would be in competition with the vertically integrated chains like Coles and Woolworths and would not be dominant. Justice Spender found in favour of QIW, saying that mere fringe activities of retail were not enough to dismiss the otherwise clear functional distinction being disregarded. Justice Spender also commented that it was unlikely competition would emerge, as there was extensive barriers to the market, such as extensive infrastructure costs and poor profit margins, and as such, a vacuum of competition could be expected, as combined QIWs and Davids had the capacity for a protracted price war. Therefore, Justice Spender ordered an injunction as the merger would be in breach of Section 50.
In the 2011 decisions of ACCC and Metcash, the ACCC challenged Metcash's proposed $215 million takeover of Franklin's 80 corporately owned supermarkets. Metcash operates both as a wholesaler of grocery products to independent supermarkets, as well as owning and supplying IGA-branded supermarkets. Metcash also used to supply grocery products to Franklin's, but that relationship broke down. So Franklin set up their own wholesale division, but this venture proved unsuccessful, and their South African owners, Pick n Pay, decided to leave the Australian market. In an attempt to better compete with Woolworths, Coles and Aldi, Metcash decided to purchase the Franklin supermarkets and convert them to IGA stores, but the ACCC rejected and said no to Metcash's proposal. The ACCC argued that the acquisition would breach Section 50. They presented counterfactual scenarios where if the acquisition proceeded, there would be a real chance that competition in the wholesale supply to independent retailers market would be substantially lessened. But if the acquisition was stopped, a consortium of independent retailers would instead purchase the Franklin stores and establish a competing business to Metcash for supplying independent retailers. Metcash and Pick n Pay rejected the counterfactuals and denied that market existed, saying only Woolworths and Coles were viable alternative purchasers of Franklin's. In the federal court, Judge Emmett agreed, holding that there was no such thing as a wholesale supply market to independent retailers. His Honour thought the consortium lacked credibility to be an alternative purchaser of Franklin's because they lacked the funding capabilities. The ACCC appealed. The full court dismissed the appeal. Justice Buchanan even held that the balance of probabilities, rather than the real chance test, applied to Section 50.
And that concludes our cautionary tale.
For those wondering what happened next, no one wanted to buy the Franklin stores from Metcash, and they ended up having to write most of them off. Woolworths and Coles are just too strong.
So, before you consider making two become one, know your market and make sure you don't substantially lessen competition in it. Until next time.
Let's go. I hope there's no next time.
Bye.
Together forever.